Further hearing in the MV Renos appeal.
Mr. Berry.
Thank you, my lord. I was in what I might call chapter 3 of my submissions, that is to say, considerations of principle and logic, and I have completed the first part of that, which is the principle and logic that we contend for, and I now move to the second part of that chapter, which is the logic and principle that the insurers contend for, and in my submission, they make 3 points really under this heading. They take 3 separate principles and in effect they stitched them together to achieve a result that none of the principles themselves are actually directed at or require the result that they arrive at. And my lords, the 3 principles that they pray and aid are firstly that the test of a CTL or not is what they call a forward-looking test. It looks to the future. The second principle they pray and aid is that, as I think they put it, although we'll see exactly how they put it in a minute, the CTL, the vessel must be a CTL at the date of notice of abandonment and also at the date of writ.
You would accept the first proposition, provided that one's talking about future from the date of casualty, wouldn't you?
I would, but I would put it differently. I would say the word would cost more to repair is a description, a way of describing the current damage in the ship on any relevant date, but the date of the casualty. And that the future is relevant only insofar as it provides evidence of what the would cost, the hypothetical cost, is at the date of the casualty and at any relevant date, provided you count the cost from the date of the casualty. So the content of the question, irrespective of when you ask it, is what would it cost, counting from the date of the casualty.
Yeah.
So the second principle they claim is that it must be a CTL at the date of NOA and at the date of writ. But the way they put it is negatively, it must not have ceased to be a CTL by those relevant dates. And in that respect, in my submission, there is no difference in principle or analysis between must be so at the date of NOA and must be so at the date of writ. They both proceed on the same underlying basis.
If you're right in saying that you look at everything from the casualty onwards, do you actually take issue with the proposition that if for some reason, e.g. a new information about the scale of the repairs, it has ceased to be a CTL by the date of NOA or the writ? Do you quarrel with the proposition that in that situation the authorities show that you can't claim for a CTL?
I wouldn't quarrel with the result, but my submission as to the analysis being applied there is that the evidential change of circumstances in the future are the best evidence of what the damage was at the relevant date all along.
But I mean, the whole of this exercise is, as you point out, hypothetical. And because it's dependent on the amount of information available, reasonably assessed, you can have a situation in which, because the information has changed, something is a CTL at one point and not at another. I don't think you dispute that, do you? Provided it's limited to change about the information about the same thing.
I think I would disagree with that in this limited sense, that you can't claim for a CTL, but later information is information as to the true position at an earlier time. if there's a later event.
Well, it may not be. It may be, for instance, that because there was a storm after the ship originally grounded, things got worse. Now, there are sort of sophisticated arguments about causation, whether that breaks the chain of causation and so on. But basically, the new information can relate to something that happened after the casualty. I don't see why you need, for your purposes, to quarrel with the proposition that further information may mean that there isn't a CTL any longer, or possibly putting it perhaps more accurately in the way it was put in the Nomikos case, that there was a CTL, but there is no longer a damnification to give rise to a liability on the part of the underwriter. It doesn't matter which way you put it.
Well, for my submission, it does not matter which way we put it, but if it did matter, it would be the second way.
Yeah.
The damnification has gone, not the CTL.
That's clearly the effect of the authorities in relation to the position at the time of the writ.
Yes. And my submission is that the underlying principle is exactly the same. The rule, if it be a rule, or the principle, if it be a principle, is the same at the time of where the rule is at the time of NOA as where the time of writ. There is no difference in the underlying basis and rationale of that principle. And if it matters, and I submit it doesn't matter because we succeed on both bases, but if it matters, then my submission is that the content of the rule and the principle is not that it ceases to become a CTL, but that you cannot claim as for a CTL because you've ceased to be damnified to the extent of a total loss. And I will come to your Lordship mentions the Nomikos, Robertson Nomikos, and that it's clear from that, and it's also clear in my submission from the Blairmore case,
as well, yes.
Which is the height of my learned friend's case, and the Rora case, as explained in the Nomikos case, as also explained rightly in my submission by Lord Donaldson extrajudicially. And so therefore, on the second principle that my friend relies on, i.e. must be so both at the date of NOA and at the date of the writ, my true submission on that is going to be that the true principle there is not that it ceases to be a CTL, but that you have ceased to be damnified to the tune of a total loss and therefore can't claim a CTL because of a double indemnity rule or an over indemnity rule. And the third principle that my learned friend stitches together to arrive at a wrong result we would submit is the prudent uninsured principle. And he says the prudent uninsured test dictates, when put on top of the first two principles, that you freeze the position on date of NOA, look only forward, and compare the forward cost with what would be saved. Now, can I first deal with the forward-looking point? And it may be well to have the text of section 60 nearby, which is in various places, but tab 70 of bundle 2, if that's where one is looking from. And I will come later to future salvage operations and future general average, but the first point that my learned friend relies on is the would language in subsection 2, subsection 2, the would language, and I've made my submissions on that. That is not looking to the future, that is hypothetical as to the current cost of repair, the current damage to the ship. And the other point I would make about that is that the policy wording has the would wording, but it doesn't have the future wording that we see in subsection 2. And so the question arises, before coming to the actual future wording, what is the role of the future in assessing whether the cost of repairing the damage would exceed the value of the ship when repaired. And my submission is the role of the future is purely evidential, in the sense of it provides evidence of what the ship would cost to repair at the date of the casualty, and also has an impact on the knowledge of the owner at the relevant time, but no more effect. In other words, to summarize the submission, the only effect of the future in this test is an evidential one. And can I invite you to look at Arnold, just to identify the kind of general approach to this, which I say supports that. And that's
just before we do, Mr. Berry, can I just raise this with you? I've been thinking about the exchange between yourself and Lord Sumption. When yesterday we looked at what Lord Wright said and what Mr. Justice Roche said, the effect of that, as I understood it, was that the test under Section 60 is based on probability rather than the event, as Mr. Justice Roche puts it. And so a constructive total loss can occur on the basis of the state of the probabilities, as, for example, when the ship gets captured by the German warship and it's unlikely to be recovered. There is at that moment a constructive total loss. But you distinguish between that and the right to claim for a constructive total loss, which will not exist if the ship has actually been restored, whether that's through its unexpectedly being recaptured, or it may be an exceptional wave lifts the vessel off the rocks on which it was grounded. But one way or another, the event doesn't negative the constructive total loss, which earlier was apparent on the probabilities, but it bars a claim and therefore recovery for a CTL, because you no longer have a claim for indemnification because you've got your property back, effectively. Is that the way you're asking us to look at it?
That's exactly the way I'm asking your Lordship to look at it. And the form of wording that I would invite you to summarize that thought is that of Lord Porter in Nomikos, where he says he's already been indemnified by the restoration and can't be indemnified again. Not that there's no CTL, there is a CTL, but he's already been indemnified by it. That is the Robertson case. Just
yes, and that's the one where I was referring to Lord Wright's speech as well.
Lord Wright is to the same effect.
Yeah.
Yes,
it's tab 22.
Yeah, it's tab 22, page 746. Lord Wright is to the same effect, my lord. But if one is looking for a neat, pithy, verbal encapsulation of it, it is 746.
Yeah.
Lord Porter, and your lordship will remember that three of their lordships agreed with each of Lord Wright and Lord Porter. Had she been just below the words Lord Porter, the line following that, had she been insured and notice of abandonment given but not accepted, the right to recover upon the hull policy would have been precluded, not because she was not a constructive total loss. Now that must mean at the relevant date, i.e. at the date of the writ, but because she had been restored. And the owners who had been indemnified by the restoration could not claim to be indemnified over again. So she's a total loss to you, but you've been indemnified, in fact, by restoration of the ship. Mm-hmm. And I know there certainly were some forms of policy in the old days where the underwriter could indemnify by giving you the property back or the equivalent property, and that would be indemnification.
What if you're not wholly indemnified by the restoration of the ship? I mean, take the example given by Lord Reed of the exceptional wave that lifts the ship off the rocks. There is therefore still some damage, but it's pretty minor. Now, on the footing that there has been a total loss because of the position at an earlier stage, one would expect there to be a right to claim on a partial loss basis for the more limited damage that has happened. So how does that fit into your analysis? Are you saying that basically you can still claim in theory for a total loss, but you can only be indemnified up to the amount of the damage which has occurred? What is the analysis?
You can only count towards your total loss claim the unindemnified portion.
So you are still, in other words, making a total loss claim, but it's only recoverable so far as you would have been entitled to recover on a partial loss basis for the more limited damage that has happened. Is that the answer?
Not quite. The answer is you're only allowed to count towards your constructive total loss on the basis of adding in the unindemnified portion.
Yes, well, I think that amounts to the same thing.
If it does, then I agree. If it doesn't, then I maintain that submission.
Right. It's a slightly awkward juxtaposition of two concepts, isn't it?
It is. It is. But nevertheless, there's the highest authority for it, and it's the principle. And what I'm doing here, just to put it in setting, is answering my learned friend's case of principle and logic, which he says drives you, as I would analyse it, to limit the cost of what would the cost of repair be under Section 60 to only a portion of what would the cost of repair be, that is to say that after the notice of abandonment. So it's my learned friend who needs clear logic on his side in this context, in my submission, but without prejudice to that, as it were, that is the nature of his principle. The principle that he relies on must be a total loss at the date of NOA. I say no such principle.
I mean, you are obviously absolutely entitled to say that your analysis is supported by cases like the Blairmore and the Nomikos case. Looking at it as a matter of principle, one of the problems about the authorities is that they often only consider the particular facts of the case, which may raise only some of the problems associated with some particular analysis. The alternative view is that something may in fact be a total loss at point of time 1, but not at point of time 2, and therefore the only circumstances in which you can really say once a total loss, always a total loss, are that the notice of abandonment has not only been given, but has been accepted, thereby becoming irrevocable. Now, I entirely see that that's not what is being said in those two cases, but the problem of the reduced damage when the ship has come off the rocks may indicate that it's a more satisfying solution to a broader range of factual possibilities. And it doesn't matter from your point of view anyway.
Yes, which is why I haven't previously thought that.
I mean, your job is to win, but our job is to get the law right.
But,
Yes.
Lord Porter tells us in lines 5 to 6 on page 746 that one must regard the ship as having been lost as soon as it became unlikely that the owners would recover her. But in terms of Section 61 of the Act, we're told that where there is a constructive total loss, which on Lord Porter's approach there is, there's a right of election whether to treat the loss as a partial loss or to treat it as an actual total loss. And presumably, if you've been at least partially indemnified, you therefore cannot elect to treat it as a total loss. I presume,
Quite.
and serve a notice of abandonment.
If the partial indemnity takes out so much of the cost of repair, that means you don't hit
Yes.
the
Well,
insured
even if
value,
it doesn't, because if you've claimed for a partial loss and it's a right of election, you can't possibly then say, well, I think I'd rather have a CTL after all.
I didn't mean to say that if you, in fact, have elected, you can unelect. I meant to say that if you haven't elected but have been partially indemnified, then you can only count the unindemnified part.
That's what I meant.
But equally,
That's how I understood the question.
a notice of abandonment which hasn't been accepted presumably can't itself constitute an election, because under, I think it's subsection 4, it only becomes irrevocable when accepted by the underwriter. So, I mean, I can quite see that if you've actually claimed for a partial loss, that may constitute an election. In practice, of course, they all wait for the thing to play out. Nobody accepts a notice of abandonment or pays on a partial loss until they know what happened. But it is the case, isn't it, that you can withdraw a notice of abandonment if it hasn't been accepted?
Yes, my lord, and it may then be that this election, in that respect, is a statutory curiosity or a common law curiosity, in that your initial election works also as an offer.
It's not an election at all unless accepted, is it? Because of the Act providing that it's revocable.
An election to abandon, an election that way isn't, but an election the other way is, because it doesn't require acceptance, the election to repair.
Yes.
So it's an election with those superadded features deriving from 18th and 19th century authority in the Act. But yes, but it's still an election. And it's certainly an election if you repair. And that's the explanation of the American. I'm moving forward. Can I just go back then to the forward-looking test and just show the authorities which, in my submission, support the proposition that the future, it's not a future-looking test, and the only relevance of the future is the evidential one. And this actually is the same point as my Lord Reed's point, that it's a matter of probability. Certainly in the capture cases, there is a question about whether that reasoning can be applied to repair cases. But my learned friend's whole submission is that they can. And on that hypothesis, that is to say the date of NOA rule can be applied in repair cases. And in that context, can I ask you to look at Arnold in the latest edition at tab 45 of Authorities Bundle 2 at page 1292, where the principle that my learned friend relies on is stated.
Which page?
1292 of the bundle, 1534 of the text, and paragraph 2907. And the heading is that the notice, which is a notice of abandonment, must be justified by the facts as they exist at the time it is given. Now, that formulation is not the vessel must be a CTL at time, but the notice must be justified, and it's a notice to abandon, so the abandonment must be justified. And can I just ask you to look then at the footnote 51, which is in the sentence that describes the rule. Not only must the information on which it's founded prove true, but it must also be justified by the state of the facts existing at the time actually given. Footnote 51. Marine Insurance Act, section 61, declares, and that's the declaration as to the loss of possession. These words do not mean that an assured can recover merely because he or the master or agent honestly and reasonably believed loss was unavoidable, and they say that the facts must exist. And then if I can invite your lordships to look at the next page, the continuation of the footnote at 1293, in the middle of the footnote after the citation of the Macefield case, which was a piracy case where the pirates seized it, but they didn't seize it to keep it, they seized it to ransom it. These considerations. The same considerations apply to the requirements of a valid notice of abandonment within the meaning of section 61 and 2, Rickards. In Rickards, Lord Porter said, "One must not judge by the result, but from the probabilities as they would have appeared to a reasonable assured the moment when he knew of his loss and could have given the notice, had notice been required. The scrutiny is to be performed on the basis of the true facts at the time when the notice was given, not simply on the facts as they may have appeared at the time, but the probabilities as to the true facts at that time regarding the prospects of recovery within a reasonable time may be tested in the light of subsequent events." Now, if this principle must be justified at the time of notice applies at all to repair cases, then that concept in my submission will also apply. And can I invite you to look at an American case now, not because it's authority for anything, but because it is illustrative of principle. And that is the Bradley case on this line of country in tab 37. And I'm going to come back to the Bradley case on the very issue a little bit later, so if I can sweep that up now as well. But tab 37, page 1226, and this is Mr. Justice Story, who my learned friend described as the great Mr. Justice Story, in the US Supreme Court in 1838. And I could tell you, I summarize the facts which appear from page 1235 of the report, but if I simply summarize it, there was salvage and a liability for salvage predating NOA, then an NOA, and the question, the judge directed the jury that they were to take into account the salvage in assessing the total loss, and of course the American rule is that it's a constructive total loss if the cost of repair exceeds half. So the judge directed the jury that you add the salvage plus the cost of repair and see if it's more than half. The insurer objected, well, that was tested, and in short, Mr. Justice Story said that was the correct direction. And I rely on that in the latter part of the case as to what the pre-act authorities show. But for present purposes, it's really the head note at 1226 at the bottom. In cases where the abandonment was founded upon a supposed technical total loss by damage or injury exceeding 1/2, although the fact of such damage or injury must exist at the time, yet it is necessarily open to proof to be derived from subsequent events. Thus, if the repairs, when subsequently made, clearly exceed the half value, it is plain that this affords one of the best proofs of the actual damage or injury. On the other hand, and then he posits the opposite situation, in many cases of stranding, the state of the vessel may be such from the immediate imminency of the peril and the apparent cost of the expenditures as to justify an abandonment, although by some fortunate occurrence she may be delivered without an actual expenditure, where in circumstances in which the vessel then may have been, in the highest degree probability, the expenditure to repair her will exceed half the value, and if her distress and peril would be such as to induce a considerate owner uninsured on the spot and to withhold, the abandonment would be good.
So the submission is that the reasonable opinion, as at some particular point of time, is only relevant as evidence of what will happen in the absence of actual knowledge of what has happened.
I would put it the other way around. What actually happened is only evidence of the reasonable opinion at the time.
Yes. So we only look at reasonable opinion about those things which are not actually known.
Yes, because it's the best. No, not quite. What actually happened is usually the best evidence. And then in practice, one only ever looks at what happened. And for example, in this case, we actually pleaded as the cost of recovery the salvage award that was eventually made, albeit later. So just on the facts of this case, they appear from the pleadings that at the time of the notice of abandonment,
if the salvage award had come out for a smaller sum, your expectation of what it would say would be no longer of any evidential worth.
quite. the best evidence of what our expectation should have been is what actually happened. But not always, because if I can just show a passage at 1240, that was the head note. If I can just show what Mr. Justice Story actually said at 1240 on the point. What one can see, this is part of the judgment of Mr. Justice Story from the bottom of page 1234. That's where the judgment starts. And so at 1240 is the ipsissima verba of the judge, ipsissima verbi of the judge, at 1240 in the bottom, which was summarized in the head note. And there's an exact summary at 1240 to 1241, but it goes a little bit further than in the head note. So therefore, at the top of page 1241, thus, for example, if the repairs when subsequently made clearly exceed half value, it is plain that this affords one of the best proofs of the actual...
Sorry, where are you reading from?
I'm sorry, top of page 1241, I beg your pardon. Trying to read quickly. At the bottom 1240 is the part of the judgment which is kind of replicated in the head note, but at the top of 1241, his lordship goes a little bit further than was in the head note. It's necessarily open to proof to be derived from subsequent events. Thus, for example, if the repairs when subsequently made clearly exceed half value, it is plain that this affords one of the best proofs, and that's in the head note. On the other hand, and that's in the head note. And then this, but it is not, and in many cases cannot be decisive of the right to abandon, he says that may not be decisive, and that follows from the best proof concept, and then later on he makes the same point. I'm not sure it matters, but there is a theoretical possibility that the events which happen, for whatever reason, are not actually the best evidence. For example, perhaps if there's a significant new event, a new intervening event, something of that nature. But the theory of the matter, whatever the possibility of exceptions to it, the theory of the matter is the future is relevant because it's evidence of the position at the time, and that element of futurity is different from, and what my learned friend says, the future-looking test. It's not a future-looking test. The future is relevant to tell you about what the cost would be today. And I won't come back to it, but the passages in which I won't come back to it, so I'll deal with it now. But the passages in which sub silentio, I accept, and my Lord Sumption made this point to Mr. Ashcroft yesterday, sub silentio, the direction to the jury which was challenged is at page 1238. In the middle, if the jury find that the Gracchus was so damaged by the disaster on March 25th that she could not be got off without exceeding half value, then the plaintiffs are entitled to recover for a total loss under the abandonment made on 22 April. And in ascertaining the amount of such expenditure, the jury must include the sum for which the brig was liable to the salvors according to the decree. And if you look back at page 1235, you will find, I won't read it out, but you'll find that the salvage was rendered on the 24th to the 27th of March, that is to say before notice of abandonment. And then at the bottom, the defendants accepted the refusal of the court to give the instructions prayed, and just to summarize, one sees from 1251 that Mr. Justice Story said that the direction was correct. Without any express discussion of the fact that the salvage actually incurred before the notice, I accept. Now, to go then back to the Act, my learned friend relies, I think, certainly did at one stage, on the word estimating in section 60, subsection 2, subsection 2. But estimating does not make it a forward-looking test. What you are doing is estimating, as Mr. Justice Story said, the damage that then exists. So there's nothing future in the cost of estimating the cost of repairs, because they're hypothetical. You're estimating what these repairs would cost today. And as Mr. Justice Story says, the purpose of this is to evaluate the today's damage to the ship. Not forward-looking at all, save in terms of evidence. And then I come finally to the future. And as many commentators have said, Lord Justice Donaldson, perhaps most clearly, the second part of 62, subsection 2, is surplusage, at least in part, on any view, and is difficult to follow or to extract any general principle of futurity. The section says that in estimating the cost of repairs, no deduction is to be made. And then it moves on to the comma. But account is to be taken of the expense of future salvage operation and of any future general average contribution to which the ship would be liable if repaired. Now, if my learned friend is right, then this is surplusage, because future salvage to the date of the notice of abandonment would always be included. There was no controversy about that. It was always included. My learned friend acknowledged that. If I can invite you to look at paragraph 64 of their written case. Which is in the core bundle, section 5 at page 76. Paragraph 64, subparagraph 2, my learned friend says, as to the second point, the reason why salvage and general average expenses are singled out is obvious. There was plainly some room for doubt as to whether the cost of salvage or general average would be liable to be repaired if it fell within the words of cost of repairs. But he destroys the point by the next sentence. The purpose of the part of this provision was to confirm that they do, as held in Kemp and Halliday, 1866. And I might add, never ever doubted.
I mean, this is the effect, isn't it, of section 65.1? Because, as I understand section 65.1, but correct me if I'm wrong, this provides that salvage costs which have been incurred for the purpose of avoiding an insured peril or the effect of an insured peril are to be recovered as a loss insured, i.e. not as sue and labour car charges. So that 65.1 is on the face of it, and it reflects 19th century authority. Authority for the proposition that you treat salvage as part of the insured loss. I think that's the point that you were making by reference to the decision of the Exchequer Chamber in the 1860s, but it's statutory, isn't it?
Yes, and therefore it's the 1860s authority which has never been challenged, and therefore the reason for including future salvage in section 62 sub 2 cannot be, is, on my learned friend's case, surplusage, because it adds something that doesn't need to be added.
But he relies on it for the implicit negative. I mean, it's very difficult to know why it was thought necessary to specify future, but your submission is that whatever the reason, it can't have been in order implicitly, without saying so, to exclude past salvage costs.
That's my submission, yes.
But can I just ask for your assistance in trying to understand what this proviso is trying to do? There are two parts of the proviso. The first part is saying that no deduction is to be made in respect of general average contribution to repairs paid by other interests. If we're talking about a claim by owners on the hull insurers, that's effectively saying that you take the gross cost of repairs and not the cost of repairs net of a contribution by cargo. Right, now you then turn to the next part. Account is to be taken of the expense of future salvage operations and any future general average contributions to which the ship would be liable if repaired. Now that seems to be referring to a general average contribution not by the cargo, which is the subject of the first half, but by the ship. So essentially what is being said is that although you charge the gross repairs not net of a the cargo's contribution, if the ship has to make a contribution to some sacrifice by the cargo, e.g. if part of the cargo is jettisoned or it's damaged on transshipment, then the owner is entitled to add the general average contribution that he is required to make to the cargo owner's sacrifice. Leave salvage out of it just for the moment. Thus far, do you agree?
Yes, save with this caveat that that doesn't explain the words would be liable if repaired.
That's relevant, surely, because the general average contributions are going to depend on the value of the interests, the interest which has been protected by the sacrifice.
But that's assessed when it's salved and doesn't depend on repair or not.
It's based, isn't it, on salvage is only part of the sacrifice that may be chargeable in general average. So you could have a situation in which the repaired value of the ship is the measure of the interest which has been benefited by the cargo's sacrifice.
Well,
let's suppose you need to
question that. It must be the value of that which is handed back by the salvor to the owner.
It's not just a question of salvage, is it?
Yeah.
Suppose that the cargo interests have made a sacrifice in that it's necessary to destroy part of the cargo in order to repair the ship.
Yes.
Now, in that case, you would be looking surely at the repaired value of the ship as the relevant value to be entered in the general average calculation.
I hesitate because the alternative proposition, which I haven't checked, is that the salved value is the salvage, is the value of that which is after a general average or a salvage, which salvage is also general average. Which is handed back to ship without being repaired. Obviously, the repair cost is taken into account in assessing what the value of the thing is.
I entirely see that you are right if the only sacrifice is the salvage costs, but that's not always going to be the case, is it?
True. But it is a case by which to test what this means.
Yes. But now looking at the way that in the second half of the proviso, it's only referred to in the second half, that future salvage operations are referred to, the effect of that seems to be, although the proviso isn't very happily worded, to entitle the owner to treat future salvage charges in the same way as other elements in a general average contribution, i.e., that so far as there has been a sacrifice by cargo and the owner has to contribute to the salvage costs of the cargo, he's entitled to add those. Trying to make sense of this overall, isn't the overall effect that the owner is not required to deduct receipts of GAC from cargo interests, but he is entitled to add payments out of his own pocket towards cargo interest.
To other, yes.
That's what this is all about.
That is, my lord.
Although it's phrased in a rather complicated grammatical fashion.
And I've just had a light bulb moment, which is that for future salvage operations and any future general average, the salvage there is intended to add salvage incurred by cargo.
Yes.
Exactly.
Yeah.
There's nothing to do with salvage incurred by ship, which is already included in subsection 2 by dint of section 65.
That is the point.
My lord, I've been thinking about this case for 2 years, and and I haven't got it, obviously. But the point there is that purpose to it does not support or necessitate a statutory implied exclusion of everything else. And certainly when one is coming to construe the contract, those words aren't even there, so as to necessitate an implied exclusion of the salvage, which is included primarily. And I was going to read Lord Donaldson's perplexity as to what this was all about, but I now won't, because he didn't think of it either. That's my only, whatever, yes.
Well, if you have a further light bulb moment suggesting that everything we've been discussing so far is nonsense, perhaps you let us know.
Everything else I've said so far is sound, but, my lord, I would say my learned friend's proves too much. His exclusionary principle proves too much, because if the account is to be taken of certain things excludes everything else, then that would exclude future repair cost. The expressio unis principle as applied to this proves far too much, including things that are clearly wrong. So can I move? Can I simply say that Lord Justice Hamblin, Mr. Justice Knowles as well, but Lord Justice Hamblin had this right at paragraph 83 of his judgment. I won't take to it, but he said the fact that you have to ask the question at the date of the NOA, the fact that it's a future-looking test, to the extent that that's true, simply doesn't bear on the question. And that's paragraph 83. So the second point, and I've already really made my entire submissions on this in answer to my Lord Reed, but the supposed principle that she must be a CTL at the date of the NOA and the writ is no such thing. It is merely a principle that if you've been already indemnified, you can't be double indemnified again. And in answer to my Lord's assumption, that applies, perhaps with some logical bumps in the road, to the partial indemnification. And can I just show you in this context, I just remind you of Hamilton and Mendez, which my Lord's assumption was right. That was the case where notice of capture and recapture, notification of capture and recapture were received at the same time, and the owner then gave his notice of abandonment. And the Bainbridge case, where notice of capture preceded notice of recapture, and in the interim notice of abandonment was given, but the writ was not issued, and the recapture was held to take away the damnification.
Sorry, which case is that?
Bainbridge.
Yeah.
Perhaps I will show you Bainbridge just very briefly. It's bundle 1 of tab. It's bundle 1, tab 1 of the authorities.
Menendez and Hamilton is Lord Mansfield's very clear statement that the whole basis of this is that you don't give an indemnity to somebody whose damnification has been reversed.
Exactly. And that is what I'm citing Bainbridge and Nelson for, because it cites Hamilton and Mendez. And that is the principle. It's not she must be CTL at the date of the NOA. It is that you can't be over-indemnified. So it's tab 1, page 383 of the bundle, and the facts are in the head note, but I don't think they matter. And this clear statement of principle is quoted by counsel at 386, the counsel being Holroyd, see the bottom, page 385. And as I say, this is an indirect way, because we didn't think to put Hamilton and Mendez in the bundle of of isolating the fundamental principle that my Lord Sumption has identified. So it's at page 386, in the middle of the page, and there's an emboldened paragraph 338, which refers to 338 of the original the original report, and it's this: Lord Mansfield. So it's almost exactly in the middle of the page. Lord Mansfield farther says that the action must be founded on the nature of the plaintiff's damnification as it really is at the time of action brought, for that it is repugnant upon a contract of indemnity to recover as for a total loss, when the final event has decided that the damnification is in truth an average or perhaps no loss at all. And that is the principle applied by Lord Ellenborough, whose judgment starts in the middle of page 387, and I won't read it, but the passage that implements the Mansfield principle is at the lowest part of page 388, just before the beginning of the judgment of Mr. Justice Gross.
An average, in Lord Mansfield's terminology, means a partial loss, doesn't it?
Yes, it does. And the damnification point is in the last, I suppose, the last 10 lines at the bottom of page 388 of the bundle, which is 805 of the English report and 344 of the original report in East. Maybe not East. I'm maybe wrong about that. In East, 10 East. So the principle is a damnification. It's not a CTL principle. And again, and Blairmore. Then can I show Blairmore?
It's interesting how it's put. Lord Donaldson picked this up, that the last dozen lines or so is saying, though there was a total loss, subsequent events are deemed of a loss.
Yes. To use the word, this is the principle of redemption of loss. It is not the principle which is not a principle that you must look at the date of NOA and forward only. So perhaps. So really, my learned friend's second principle is not, as he describes it, it is the principle of redemption, i.e. only for that which you're damnified. And perhaps I can take Blairmore a little quickly in the light of indications that your lordships have picked up the point in Blairmore. But can I invite you just to look at parts of it that my learned friend didn't look at in tab 12 of bundle A, the authorities 1. The facts were that there was notice of abandonment. The underwriter then himself raised the ship, and then said, as at the date of the writ, the only thing left to you is cost of repair, which is under the insured value. And the decision of the House of Lords was that even so, he could claim for a CTL, and the underwriter couldn't rely on the fact that he had raised the ship between abandonment and writ. And there was an issue as to whether Scottish law was the same as English law, this being a Scottish case, as to the relevance of the date of the writ. That was not decided, but assumed that Scottish law was the same as English law. And where I would like to go to is page 543 of the bundle, which I'll come back to Lord Herschel, Lord Halsbury later, but 543 is the start of the judgment of Lord Watson, one sees at the bottom, and then at 545 is the issue, in the bottom half of the page, 545 of the bundle, 601 of the appeal cases reports. The plea direct against the relevancy of the action, and so on, which is one of law, not fact, is whether the appellants, in calculating the total loss for which they claimed, were entitled to take into account either the costs of raising and righting the vessel, which had actually been paid by the underwriters, or an estimate of the expense which would have attended that operation if the underwriters had not intervened. The respondent, i.e. the underwriter, argued that neither should be taken into account, in essence, because, I summarise, the underwriters had already done it. And then the last line at page 545, and that the fact of her having been raised by the underwriters at their own expense placed the insured in the same position as if the raising had been effected by natural causes, such as the volcanic action of the bed of the sea or by some neutral purpose, acting in furtherance of his own purposes. And the appellants responded that, firstly, by the point that Scottish law at a time is different. We can pass over that for the moment. In the second place, they maintained that assuming the law of Scotland to be the same as that of England, both as to time at which and the manner in which a constructive total loss ought to be ascertained, whatever might be the effect of a change of circumstances produced subsequent to the notice of abandonment by natural causes or neutral operations, the underwriters cannot legally affect their operation. And then my learned friend referred to page 547, which I will come back to, but at 551, we have Lord Watson considering the second problem, that is to say the content of English law. He says, I shall assume, first, the Scottish law point, and second, also, that if the Blairmore had been raised after notice of abandonment and before the date of the action by the operation of natural causes, or by the action of neutral persons without expense to the insured, the appellant would, according to English law, have been disabled from claiming under their policy. And so the principle stated there is exactly as I have submitted previously. This rule, whatever it is, redemption of loss or time of the NOA must be a CTL at the time of writ and also NOA, only applies where there's been redemption without cost to the owner.
That's because the cost to the owner are insured.
Yes, and therefore he's still damnified. Still damnified. And it goes on. This is perhaps interesting, but I'll come back to it. Further down this page, the question remains whether the gratuitous act of the underwriters in raising the vessel at their own expense, leaving nothing but the cost of repair to be informed, will have the effect of reducing a total to a partial loss. It might be that in every case where the ship has been raised by causes which entail no liability on himself, a prudent uninsured owner would repair the vessel. So, excluding the case where it entailed liability on himself. But I've been unable to arrive at the conclusion that in the circumstances which occur in this case, the consideration of what would be the action of a prudent owner uninsured in such circumstances affords the true test of liability of the underwriters as for constructive total loss. In my opinion, the test is excluded in this case by the contractual relations which exist. And the point there is relevant later on. My learned friend praised the prudent uninsured owner test, but this shows that that test doesn't apply in the situation of redemption or alleged redemptions of loss. And if it doesn't apply where the underwriter incurs the cost, nor does it apply where the owner does. Look, can I just show you Lord Herschel? His judgment starts at 552, and his statement of the principle is at 554, page 610 of the appeal cases reports. He says in the first main paragraph at 554 and 610, I take that the general rule is, according to the law of this country, that if in the interval between the notice of abandonment and the time at which legal proceedings are commenced there has been a change of circumstances, reducing the loss from a total to a partial one, or in other words, if at the time of action brought the circumstances are such that a notice of abandonment would not be justifiable, and that's the rule, but it's the reduction of your damnification. And Lord Shand, to like effect at page 558 of the bundle, 614 of the report, in the middle of the case, states the rule, if by natural causes or the actings of third parties, the ship had been in April 1896 restored to the appellant without cost to them, though in a disabled condition, but requiring only repairs of less cost than the value of the ship when repaired, the authorities seem to show that the owner would not be entitled to prevail on his claim. And that is a case of the sort that my Lord Sumption put to me, which is not total restoration, but partial restoration. And it shows that it supports my submission on that, which is that in that case, you count the unindemnified part of the partial, of the original loss. Now, my learned friend, to go back, my learned friend relies on the passage at 547 in Lord Watson. He says that this shows what he calls the forward-looking test from the date of the NOA, but in my submission it doesn't. He looked at the words after Scottish law the same as English law, and then he says, these laws may differ in regard to the date at which the test ought to be applied. So the concept there is date at which you apply the test. The test, as I understand it, he's now moving on to the content of the test, is simply this, that in order to instruct the total constructive loss at the date to which the inquiry relates, now that is different from the date at which the test ought to be applied. And my learned friend's point only applies to, it's only the date of application is NOA, but the date to which the inquiry relates is a different thing altogether.
What date is the date to which the inquiry relates?
The date on which, in this particular instance, the date on which the expenditure is incurred. Because it says it must be shown that a ship owner of ordinary prudence and uninsured would not have gone, remember the context of this, it's already been raised, would not have gone to the expense of raising the vessel, but would have left her at the bottom of the sea. Now, the date at which the inquiry, the date at which, sorry.
Go on.
The date at which the test is applied, in this case, is the date of writ, because they've assumed Scottish law is the same as English law. So at the writ, you ask, would the insured have gone to the expense of raising? That must apply to the date at which he would have raised it. And it was already raised here.
I mean, the prudent uninsured owner test, just looking at it wholly generally, is generally a test that you apply where some decision of the owner has affected the amount of the loss in some way. And you have to ask, does that diminish the causal effects of the casualty? If the prudent uninsured owner would have reacted in the way this one did to whatever event it is, then the chain of causation is not broken. It's essentially a tool for determining the impact of the owner's decision on quantum. It's not relevant for the wider purpose of deciding, given that I've already sunk 9/10 of the cost, would I raise this in order to, what decision would I make in light of the remaining 10th?
Exactly. And my Lord, this is in the context of Lord Watson and the others saying that this principle only applies if there is restoration without cost to the owner, which doubly reinforces, and in that context, it doesn't mean what my learned friend says it means. I would add, and equally, a few pages later on, Lord Watson says the prudent uninsured owner test doesn't apply to the question we have here, in the case of the underwriter, so it doesn't apply to the question that we have here in the case where the owner incurred the cost.
Where does he say that?
That was
551, two-thirds of the way down the page.
yes.
The bottom part of the...
Yeah.
Yes, thank you, my Lord.
Yeah.
And if all else fails, I would say the prudent unknown, even on my learned friend's test and my Lord Sumption's example, sunk cost of 3, repair cost to raise it, repair cost of 3 hereafter, value of 5, the prudent uninsured owner wouldn't spend the 3 to get the 5, because he will have to justify it to his mortgagee, his shareholders, the New York Stock Exchange, whoever, why he spent a total bill of 6 to raise a vessel worth 5. A prudent uninsured ship owner, a ship owner of ordinary prudence would not act as a purely rational economic being, an econ, as a recent author has described him. He would act as a human, and he would say, if the total bill is 6, I'm not repairing. But that really...
It's enough for your purposes that if there's a succession of decisions, each involving a slice of expenditure, you ask whether the prudent uninsured owner would have made the same decision at the time when it was made.
Yes. The prudent uninsured owner test is really a kind of reality check or causation check to stop owners doing unreasonable things, and then either billing the underwriter for them or adding them to the CTL totting up process. Now, look, RORA, it's almost not necessary to come to it now because your lordships have got the point by it, but I just observe at tab 17 of Authorities Bundle 1, page 628 in RORA, all of the points previously made about the nature of this supposed principle, and it's the bit that we fundamentally rely on, which has been improved by the House of Lords in Nomikos, is at page 630 of the report in tab 17, 630 of the bundle in tab 17, 196 of the report, and it's that whole passage there. Restoration precludes recovery, not because in such a case there never was a constructive total loss, but because he can't be indemnified, and so on, if such loss has been made good. And then he says, in our case, it's the last 5 lines of that paragraph in the middle of the page. In these circumstances, as the restoration of the vessel itself to its owner did nothing to extinguish or minimize the plaintiff's loss, so it also cannot, in my judgment, operate to extinguish or bar the plaintiff's claim. And that applies to total restoration and pro tanto to partial restoration. And that is the principle that my learned friend describes as the forward at the datus of NOA principle. It doesn't assist him here. That's RORA.
Mr. Barry, if we're going to take a 5-minute adjournment, would this be an appropriate point?
Yes.
Very well. Yes.
May I now move to what I would call chapter 4 of my submissions on the pre-NOA issue, which is the authorities, and that's divided into pre-act and post-act. Now, pre-act, my submission is that these are irrelevant. And I am dealing with these to answer my learned friend's submissions that there was a clear understanding at the time of the Act, which informs the construction of the Act as a codifying statute. There was a clear understanding at that time that pre-NOA expenditure did not count. And to meet that submission, I submit that it is the opposite. And alternatively, which is good enough for my purposes, the point was an open one, and therefore you simply go to the wording of the Act. And my third submission on this is, even if the common law was the other way, it's inconsistent with the Act, and you apply the Act. And my fourth submission on that is, if all that fails, the wording of the 1983 clauses signed by these parties in 2012 is conclusive on the point. And so one can see the very narrow relevance, if any, of what I'm about to submit. And I almost make these submissions with an apology, but like one of my children say, it's his fault. And so in that respect, can I take first pre-Act English authority by reference just to one case, Rosetto and Gurney, which is Authorities Bundle 1, tab 7. my learned friend threw out a bit of a gauntlet here. He said it's not apparent that the relevant costs there were before notice of abandonment, so can I just show you that? And that appears from the report in tab 7, not the report in tab 6, because as pointed out by the editors of Arnold, the Law Journal report is fuller than the other. And can I just say that our submission on this is in paragraph 45 of our written case. So in the Law Journal report in tab 7 at page 420 of the bundle and 257 of the report, and I'll take the internal reports because sometimes the bundle becomes a bit obscured, the bundle numbering becomes a bit obscured. And it's in the right-hand column at page 257 that one has the dates. Your Lordships will see just above the first hole, the Hebe sailed from Odessa on the 18th of July 1848 with wheat for Liverpool. And on the 29th, she was stranded near Constantinople, and it became necessary to refit at an expense of £1,800, for which a bond was given for £1,850. The voyage then proceeded till the vessel arrived near the Cove of Cork, where she was again so much damaged by stress of weather that it was necessary to run her ashore. She was afterward towed into the Cove of Cork by a Coast Guard boat and a steamer, and salvage was claimed. So the salvage is in towing it into Cork. The wheat was at this time in a very damaged condition, and a notice of abandonment was given. And so clearly the notice of abandonment was given after the salvage, and that's the basis of that submission. Those are the facts. Can I just, in passing, because I'm not going to refer to Holdworth and Wise, look at the bottom of page 258 in the argument of Mr. Knowles, Mr. Crompton and Mr. Blackburn on May the 6th and the 7th. One sees that in the middle of the left-hand column at page 258. At the bottom of the right-hand column, Gernon is cited, and then a few lines further down, the assured may recover for loss by salvage, even if not specifically alleged as a loss in a declaration on the policy. Arnold, Holdsworth is a case precisely in point, for there, after abandonment, the ship was repaired and sent home, but subject to claims for salvage and repairs equal to or exceeding her value, and it was held that there was a total loss. And on the facts of that case, the salvage was predated abandonment. The salvage was the ship had been abandoned and another crew came on board and took it to New York. And relevant to the present case, at 262 of the report is what the Chief Justice said was the correct direction. He was speaking for the court, which was the Chief Justice Jarvis and Mr. Justices Cresswell, Williams and Telford. We see that earlier on. Perhaps 12 lines down in the right-hand column at page 262, his lordship says, the jury having found that 1,700 quarters could have been dried and conveyed from Cork to Liverpool at a cost less than their arrival at Liverpool, it is plain that the verdict cannot stand for a total loss. It's plain also from the form of finding that the jury took into their consideration only the cost of drying and transit to Liverpool as the basis of their calculation. We think this was not the true test and must therefore be a new trial. The question to be submitted to the jury will be, was it practicable to send the whole or any part of the cargo to its place of destination, Liverpool, in a marketable place? To determine this question, the jury must ascertain the cost of unshipping the cargo, and so on and so on and so on. And then 5 lines further down, add to these items the salvage allowed in proportion to the value of the cargo saved, and the loss will be total if the aggregate exceeds the cost when delivered at Liverpool. So although the test, you could say, is being applied at the time of the notice of abandonment while the vessel was in Cork, and the test was it practicable, which is just would the prudent uninsured do it, to send it on to Liverpool, nevertheless, his lordship says you must add in the cost of the salvage, which, as we have seen, was previously incurred. Now, it is right that there was no explicit consideration of the point, and as far as I can tell from the argument as reported, no actual objection to the salvage on grounds that it was pre-NOA. There was objection to the inclusion of salvage on other grounds. Nevertheless, his lordship assumed that in deciding whether it was, as he puts it, practical to forward it to Liverpool, you add the salvage. So, sub silentio, that's authority in our favour and against my learned friend, and contrary. Bear in mind the context of this. My learned friend is saying the position of the common law was so clear in his favour that as the Marine Insurance Act was a codifying statute, you should take that into account, and that submission fails on a number of levels, only the first of which is that the law wasn't clear. If anything, the assumption was the other way. Mr. Carver in Buffalo, my lords, this was a proposal as to what the law ought to be, and not a description as to what it was. And can I briefly show you the passages from which I submit that can be derived? It's the second bundle of authorities, sorry, tab 72. And it starts really at page 1499. And the question he's considering is just below halfway down the page at 1499. I come now to the question, when ought the test to be applied? And he says the English rule is at the date of the writ as well as the date of the NOA, and the continental rule is the other. And he says on that, what ought to be applied is the continental rule, i.e. ignoring ademption to the date of the writ. And he says that's because of election. And then at page 1500, in the middle of the page, as regards subsequent events, now, because of what his recommendation has been, that means subsequent to notice of abandonment, but only because of that recommendation, they ought to be ignored. Sorry, subsequent events ought to be, that's irrelevant, strike that. It's as regards precedent events that we're concerned with. I beg your pardon, the subsequent, it's still in the ought clause. As regards precedent events, they ought also, I think, to be ignored, but I am not sure that that has always been done. Well, he clearly has in mind Rossetto and Gurney, etc., Holdsworth and Wise and the like. And then he says over the page, no system of law does that, so far as he knows, is estimate the cost of recovery and repair as at the time of the casualty. But that doesn't answer the question. You estimate the cost of repair at the time of NOA or writ. It's merely a question of what you take into account. And as we've seen previously, for example, in Rossetto and Gurney, you take into account a prior cost, provided it is a cost to the owner and has not been indemnified separately. So there's nothing in Carver, or the fact that there are some nice words said about Mr. Carver's great report and so on, that assists my learned friend here as to showing, as he would show, a clear rule at the date of the Act. And I may say, if one reads the whole of this, one gets the very strong impression of Mr. Carver and other English lawyers going to America and speaking to the Europeans, only two of whom turned up, and trying to persuade them of the merit of the English way, and getting very short shrift, because there are very many interventions from American lawyers and some continental lawyers saying the English way is not right, and let's have a committee. And I won't read it, but the Danish contribution could have been written by Mr. Jean-Claude Juncker. But anyway, we'll move on. So, proposal for law reform, international law reform, what ought to be, not any kind of proper analysis of what English law was at the time. American authority, I'll come to the ones that my learned friend relies on, but I'll preface it by saying that Bradley in the Supreme Court, again without express consideration of the point, was a case where a jury direction was upheld by Mr. Justice Story that the salvage ought to be included, though incurred before notice of abandonment. And so the fact that that was sub silentio approved by the court shows that my learned friend cannot be right, that there was a consensus the other way before the act. And then I come to the two cases that he relied on, and in short, those two cases merely illustrate the rule in section 61 of our Act and 62 of our Act that you have an election, and if you elect to repair, then you are not entitled to claim for constructive total loss. And my learned friend struggled manfully against that when it was put to him by my lords, but he did so against the face of the wording, not just the wording he recited, but other wording as well. And so just for completeness, can I show you that in tab 35 of this same second volume of the Authorities? It's page 436 internally of the report. And my learned friend, he did read this part, and my learned friend said, applying the doctrine to the present case, how can it be said that at the time of the abandonment there was a total loss? Now what he means, translated into English terms, is that there was a claim for a total loss. The vessel was safe and so on and so forth. And then he says, it is true that that the vessel had been injured more than half a value, and if the owner had then elected, he would have been justified. But the owner is in no case bound to abandon. He's entitled to repair at the expense of the underwriter and proceed in the voyage. In the present case, he elected through his agent, the master, to make the necessary repairs. And that is the ratio of the case. And it's established by the passage at 437 in the middle, to which attention was drawn when Mr. Ashcroft was making submissions. And then at 438, the last passage of the first paragraph there is the same point. It's about election. That is how, that is the proper interpretation of Humphrey itself, and is the interpretation authorised by the next case, Dickey.
Mr. Berry, before you leave this case,
Yes.
It appears to be authority also for the proposition that the mere fact that you have given a security, secured some liability on the hull, does not make the bottomry bond in this case, notwithstanding that it led to the loss of the vessel, could not be said to have led to its loss by an insured peril.
Yes.
Is that potentially relevant to your Scopic case? Don't answer that now. Wait until you get to the Scopic case.
Yes. I will do both of those things. Yes. Dickey in the next tab. Now, you'll recall that as I submit, the decision in Humphreys was election by the master as agent. And what happened in this case is that the master did effect repairs, and the underwriter relied on the Humphreys case, and at 1223 of the bundle, the pages being in this report legible, at the bottom of the left-hand column, the New York judge says this: the precise question under consideration now came before the circuit court for the First Circuit in Humphreys. The facts were substantially the same as in this case, and it was there decided that the repair of the vessel by the master took away the right of the owner to abandon. Judge Story puts his decision in that case on the ground that the master acted as the agent of the assured in making the repairs. Counsel for the plaintiff contended that the master acts for the benefit of whomever it may concern and is not to be considered the agent of the assured so as to deprive him of the right of abandonment without his knowledge or consent. And this is the important point. If the master is the agent of the assured in such a case, it would seem to follow that an election to repair and the actual commencement of the operation would deprive the owner of the right to abandon. And that is not only the correct reading of Humphreys, but the reading authorized by this case of Humphreys. Now, in this case, the interesting point was taken, is the master the agent of the owner for the purpose of electing? Held not in the next few lines. But why is that relevant, if my learned friend is right? It's only relevant because the only question here is election or no. In other words, this case is about what we in Britain would call a Section 61 point election, not a Section 60 point.
The point is, no English court would arrive at the conclusion that the master was the agent of the underwriter in circumstances where the underwriter hadn't elected to accept an NOA and take possession of the ship.
I'm not defending the I'm not defending the judgment, my lord. I'm merely saying that it's nothing to do with the point that my learned friend cites it for. And yes, there is a serious oddity there in English eyes. But the fact that they had to go to that oddity was only, the reason they had to go to that oddity was because what was being argued was election by the master to repair. And I think in this, or perhaps the other case, that they actually put further cargo on board after repair. But anyway, that's not an essential. Now, Mr. Senator Allen, quite clearly at this stage in the United States, they didn't have the same division of responsibility as they do in this court if Mr. Senator Allen is sitting in as a judicial capacity. But anyway, we'll move on from that. The ratio of this decision, my learned friend read the right-hand column down to the principle is clearly recognized in the case of Humphrey, in the right-hand column at page 1224. But my submission, the ratio of Mr. Senator Allen, is in the last 3 lines of that very paragraph, having described the facts in Humphrey. A bill was drawn on London by the master on account of the expenses of repairs, which was not paid. Mr. Justice Story held that this was a partial loss. He said that the assured, by electing to repair, lost his right to abandon. And so my learned friend's submission to your lordships yesterday that these cases are not about electing, causing you to lose your right, but about the non-CTL nature following the repair, was an unusually bold submission. And so, if it matters, American law and English law at the date of the Act assumed that you did include pre-NOA repair and salvage expenses, subject, of course, as was the case then in English law and is now under the Act, to electing to repair under Section 61. And if it matters, that supports my construction of the statute as a codifying statute, but it's not near the, it's not, certainly not a point in my learned friend's favour. Post-Act authority, my learned friends rely on the case of Hall and Hayman. That was the concession, and this has been much considered in the skeletons and below, and I don't want to repeat much, other than to identify one interesting feature of the Hall case, and perhaps I can take that by reference to tab 14 of bundle 1 of the authorities, which is the reports in the ComCAS. This point wasn't even reported in the KB, The point about the pre-NOA expenses was only reported in the Comcast, and one sees from page 983 that Mr. Bailash KC was leading for the plaintiffs, and one sees that at page 587 of the bundle, which is in fact 89 of the report, although there's a misleading duplication of page numbers there. At the bottom of 587, his lordship says, "It is said that I ought to allow that nevertheless." Mr. Bailash conceded that if that had been done by the ship owner, he could have not claimed that as part of the repairs because they were not future salvage operations, but he said it was done by the underwriter. And that's the concession. It's a concession about the word future in the Act, and we have submitted that it's wrong for all the many reasons, including those of Mr. Justice Knowles and Lord Justice Hamblin and Lord Donaldson and Arnold. And can I show you that in Arnold then, which is at, this is Arnold in the 15th edition, Authorities 2, tab 41, page 1264, if I may. And this is the edition of Lord Chorley and Mr. C.T. Bailash, M.A., son thereof. And 1265, we have this at 1118. Sorry, this is the 15th edition, which is 1961. The reference in subsection 62.2 of the Act to future salvage operation creates a difficulty since the Act does not state with reference to what time they are future. In Hall, it was assumed by the plaintiff's counsel, father of the editor. And then it says further down, on principle, it seems that the relevant date is the date of the casualty, independent of notice of abandonment, and he cites all the principles of, that I cite. Independent of notice of abandonment, if the notice of abandonment is rightly given, the loss dates back to the casualty, and the test for ascertaining presumably ought to be applied actually notionally on the same date, all of which we submit. And it is a reasonable historical inference that Bailash père spent 40 years regretting his incorrect concession and instructed his son to cure the record. But being serious, the reasoning here is much sounder than the unreasoned concession there, and the same point applies to the Medina Princess. The way the Medina Princess has mercifully been copied into this bundle conceals the fact that it was a 400-page judgment, of which the point in question was one paragraph of 400 pages, and there clearly wasn't time to argue the point of law, however much time there'd been on the evidence. And for the reasons in our written submissions and in all the other cases, the Medina is an unreasoned first instance matter. You know that we rely on Arnold, and you know that we rely on Lord Donaldson's Lord Justice Donaldson, MR as he then was, and essentially his reasoning is entirely correct and supportive. And those, my lords, are my submissions on the NOA point. If I can summarise them by saying simply, just look at the wording. It decides, it means what we say it means, and considerations of principle indicate that it says what we say it means. Considerations of justice say what we say it means, and your lordship should so find. Unless the questions further on that issue, I'm going to go on to Scopic now, if I may. Now, the context of the Scopic debate is the nature of a CTL. And what one is saying in the CTL is that the hypothetical cost of repair at the date of the casualty, although informed evidentially by later events, exceeds the cost of the insured value, and the loss is at and retrospectively dates back to the casualty. And so the in principle, the relevance of costs, such as the scopic costs and all other costs, is as evidence of the quantum of damage to the ship. I'm repeating a submission I made earlier on, but it's essential context to the scopic issue. And so the question is primarily whether those costs, which we've described as scopic, can be countered in circumstances where their only relevance is as evidence of what it would cost the ship owner to, in this case, recover the ship, because salvage is recovery, not repair, usually. Against the context that the scopic cost is relied on evidentially, how can it be said that it is not the best evidence of the cost of recovery to this owner of this ship? And that's the first issue that my learned friend raised. He says it's not a cost of recovery of the property, namely the ship. What he says is that it's really the payment of a cost to save or avoid risk to the environment, and thereby not a cost of recovering the ship. That's, as I understand, the submission. And he says that that's illustrated by Article 15 of the scopic rules, whereby, as is common practice, the scopic element, as opposed to the reward element, is insured by the P&I liability insurer and not by the hull, the property insurer. So that's his argument. He says Article 15 illustrates the point that this is really a payment to salve the environment, therefore not to salve the ship. The short answer to that is that even if that is the true nature of it, and it isn't necessarily, as we'll come to see, but even if that is the true nature of the scopic payment, to the owner it is still a cost of recovering the ship because he has to pay it as part of the price to recover the ship. And therefore to him it is a cost of
So
recovery.
you're saying that any expenditure which is a condition precedent to the ability to repair the ship is to be treated as part of the cost of repair. That's the proposition, isn't it?
Yes.
Right. Well, we can make up our mind as to whether that proposition is in principle right, but let's assume that it is. And can I ask you how it applies to the facts of this case? What actually happened in this case, and my experience always does happen, is that the salvor doesn't exercise the lien on the ship as part of the arrangements entered into at the time that you agree Lloyd's open form. A bank or P&I club guarantee is provided, and I understand that to have happened in this case. So your submission has got to be that if, in order to salvage the ship, you have to secure any liability that you incur to the salvor, then all of those liabilities, however characterized, are to be treated as conditions precedent to the right to the ability to repair the ship.
I would put it slightly differently to that. I would say the question you're asking, and this goes back to what my prefatory remarks, the question you're asking is what is the damage to the ship gauged by evidence of what later happened, and in that context, any liability that the ship owner must incur to recover his ship is a cost of recovery of the ship because it is part of the damage that the ship suffers on that day by reason of the casualty.
So was the amount secured by the bottomry bond in Mr. Justice Story's case automatically to be treated as part of the repair?
No, but it was to be treated as part of the evidence of the true quantum of the damage to the ship on the day of casualty. See, this follows from the point that these things are just evidential. But obviously, and in this case, and in almost all cases, the evidence of what happened will be treated as the best in Mr. Justice Story's words, the best proof.
Are there evidence of what? Because, I mean, it's under the Act, essentially the repair costs at common law are treated as prima facie evidence of the diminution in value attributable to the damage.
Yes.
But the Act treats the repair costs effectively as conclusive of that, doesn't it? That's what it
Well,
says.
it's the estimated cost of repair, but yes. Yeah.
So
In other words,
you say it's just evidential, but it's more than evidential, isn't it? Because the repair costs are what we've actually got to look at. It's not evidence of, it is in a sense evidence of something else, but for the purpose of the statute, it is the test itself. What does it cost to repair?
But it's what would it cost, it's what would you estimate that it would cost to repair? That's the test. So the actual test is what would you estimate it would cost to, what do you estimate it would cost to repair, for which the later actual repair cost is almost always, in fact possibly always taken as the best evidence. That's the story analysis anyway.
I mean, let us suppose that, for example, the ship owner gets into an argument with the mortgagee of the ship about whether he should repair or incur salvage costs or whatever. And the mortgagee of the ship, being entitled to take an awkward line under the usually rather extensive powers conferred in the event of a casualty on mortgagees, says, well, look, I don't like this, but I will consent to your doing this, provided that you pay me $2 million. Nothing to do with the cost of repair, but I'm not consenting to your doing anything with this ship unless you pay it. Now, on your argument, is that part of the cost of repair?
No, because the chain of causation is broken by the unreasonable conduct of the mortgagee.
I see, but it might be perfectly reasonable. He might say, well, I'm not satisfied that this is going to do any good to my security. I really understand that you take a different view. So I'm going to charge you.
But even if reasonable, it would break the chain of causation.
If reasonable,
Well, the question is, would it break the chain of causation? And your lordship has chosen an extreme example. But if he has to pay a reasonable amount,
so if it's reasonable for the mortgagee to take that line and the $2 million is reasonable, it's part of the repair, is it?
if the chain of causation is not broken from the repair, then yes. And the common law is that everything is to be taken into account. It's what you need to spend to get the ship back. I'm not actually in your lordship's example. I'm not sure that the mortgagee wouldn't be identified as an agent or for some purposes as the agent of the owner. But if a third party, for example, the Indonesian government in a casualty in the Singapore Strait, this is a much closer example because the mortgagee example raises the question, well, he as against the insurers in the world, he is behind the ship owner and acts through the ship owner. And your lordship will know that the way the mortgagees have those powers are that they put in receivers to act in the name of the owner, or they tend not to take possession because of the risks involved, or they give direction to the owner. So it's still the owner.
You can put in a receiver who will, as you say, be treated as the agent of the owner, but will act on the directions of the appointer.
Quite, but it would be the act of the owner to spend $2 million in effect for the present purposes to himself. The much better example, my lord, if I may put it so boldly, and one that does arise in practice, and just to give evidence as my own practice is arising in a case at the moment, is that of the vessel that is stranded in the waters of a foreign government, and the foreign government says, firstly, you must take this away, And secondly, you must pay this many $1 million to a local salvor, not to do anything, but to facilitate that. That would be a cost of repair because it is proximately caused by the casualty, so cost of recovery. The mortgagee case is difficult because the mortgagee is or acts through the owner.
Yeah. Now, I see that your variant of the facts may be more plausible. Right, so, but it goes down to the same point. Are we concerned with the characterization of the expenditure, or are we concerned with the question whether it had to be incurred?
Yes. And my submission is obviously the latter. And I haven't gone back to the earlier authorities, but the common law rule was often stated in a form, everything he has, what he has to spend to recover the vessel.
I wonder, I'm wondering whether it's necessarily a test of necessity, whether the expense is necessarily incurred. Obviously, salvage costs are necessarily incurred, and assuming that not troubling ourselves with the temporal point, we're here dealing with salvage costs. Now, I just wonder if in this day and age, if an element of the salvage costs is a payment to the salvager to avoid damaging the environment, whether if that might be regarded as a perfectly reasonable element of a salvage contract. And if it's a cost that's reasonably incurred, I wonder if that isn't perhaps good enough. I mean, no doubt, for example, if you were to, well, for example, salvors don't. There are all sorts of aspects of the salvage operation that one can imagine might be done more cheaply if you ignore health and safety, minimum wages, and so on and so forth. You could drive the cost down to some sort of irreducible minimum. But does that mean you can only recover the irreducible minimum if it's reasonable for rather more than that to be spent?
My Lord, the test, and I'm agreeing with you, Lordship, the test is reasonableness, not strict necessity. So if the owner enters a reasonable or reasonably enters a salvage contract under which he must then afterwards necessarily pay it, then that is a cost that counts, or rather, in the true formula of Mr. Justice's story, that is the best evidence of the cost of recovery. And my Lord Justice Hamblin said it was a necessary part of the recovery cost. What he meant was having reasonably signed the Lloyd's Open form. And in a prudent underwriter test, and this is the proper province of the prudent underwriter test rather than the province we were discussing half an hour ago, that is the prudent uninsured owner test. The prudent uninsured owner would incur this cost to recover his vessel.
The basis on which salvage charges are recoverable, and we touched on this in a different context earlier this morning, is that they are costs incurred in preventing a loss by perils insured against, Section 65(1) of the Act.
Or minimising, but yes.
Sorry?
Or minimising.
Yes. Now, your submission is that salvage charges which are incurred for some other purpose, but without which you cannot proceed to avoid a peril insured against, are included in that formulation. What we've got here is charges which have not been incurred for the purpose of avoiding an insured peril under the hull policy. They've been incurred for the purpose of avoiding an insured peril under the P&I cover. But your submission is that even salvage costs incurred otherwise than for the purpose of avoiding or minimising a loss by a peril insured against are recoverable if in practice they are a condition precedent to other operations which are incurred for the purpose of avoiding an insured peril.
That's my alternative submission.
Right.
My primary submission is that your lordship's characterization that they were incurred for another purpose is not right, because they are incurred by the owner. And what is the owner's purpose? The owner's only purpose is to salve his vessel.
Now, the owner's purpose is twofold. He wants to salve the vessel, certainly, but he also wants to avoid a liability under Article 14 of the Salvage Convention for environmental pollution, which is not an insured risk, not under this policy.
On this policy. Well, my lord, there are two purposes, and one purpose is good enough for my purposes.
Well, yes.
Cost of repair.
I'm not sure that's right, because, I mean, the Court of Appeal said, well, a salvage charge is indivisible. But that, frankly, can't be correct, can it? Because if part of the salvage charge is down to one set of insurers and the rest is down to another, one thing seems clear: they can't be indivisible.
No, they're indivisible as between owner and salvor. And if I may respectfully put my finger on...
But is that the test looked at Section 65.1? Because Section 65.1 is asking whether the peril which the salvage charge in question avoids is one which would be insured. So it is looking at the position not as between the owner and the salvor, but as between the owner and the insurer.
That's for the purpose of a partial loss claim. But the governing section for our purposes is Section 60. Is it a cost of repair, or Clause 19, is it a cost of recovery? Well, repairing includes a recovery. So, my lord, with respect, the possible point of contention in this area is the relevance of the split of insurance after the owner has incurred the liability and himself discharged it, although possibly with a guarantee from the P&I Club, possibly with the guarantee from the mortgagees, possibly by a lien. In my submission, that won't make the difference. And the question is it a cost of recovery, even though elements of it are differently insured, in circumstances where I submit, or at least I would submit generally the dominant reason for incurring it is to salve the ship. And can I identify perhaps how this arises by inviting you to look at the Lloyd's form itself, at the core bundle appendix, very near the end. I think it's 7 C18, page 369.
Sorry, can you give me that reference again?
7C18 is the tab number, and page 369 of the bundle. It is the last but one document in the appendix, just before 8.
Yep.
So this is the contract, and your lordships will see that it was dated the 23rd of August 2012, and that was the date of the casualty. It was never submitted below that this was unreasonably done.
It can't have been submitted because this is completely standard.
Completely standard. And once he signed this is a contract. If you look at paragraph A, the basic obligation, this is the one that the owner cares about. This is the primary purpose of this. The basic contractor's basic obligation, the contractor identified in box 1 agreed to use their best endeavours to salve the property specified in box 2.
That's the ship.
Yes.
So the basic obligation is to get the ship out of danger.
Yes.
Then while doing
And Paul,
sorry?
sorry, yes.
While doing that, B, they've got to prevent or minimize damage to the environment. Now, from the point of view of the owner, he is doing two things, isn't he? Which I don't think it's possible to arrange them in an order of importance. First of all, he is rescuing, or getting someone to rescue his property. Secondly, he is saving himself from a potentially very large public liability for environmental pollution, which if measures are not taken to control it, would be his liability.
Yes. But he has to, but he has to pay the entire bill for this contract. And the bill for this contract in this contract is unitary and indivisible. And the primary purpose, the basic purpose, is to salve the ship.
Suppose that the owner had entered into two contracts. He'd entered into a salvage contract simply to salve the ship, and he'd entered into a different contract with another enterprise to put booms around the ship to avoid the escape of bunker oil or cargo oil. Right? Position be different or the same?
It may well be different.
Why is that?
Because it was a separate contract at a separate price.
So it's just the form of the contract that determines this, is it?
No, it's what the owner has to do to salve his ship.
Well,
What the owner has to do after he has reasonably entered this contract.
Does that mean that there is a different approach in relation to constructive total loss than there is in relation to partial loss in terms of salvage charge recovery? Because I'm thinking of 65 subsection 2, which for the purposes of partial loss defines salvage charges as charges recoverable under maritime law by the salver independently of contract. And I wonder if I don't know if that has any bearing. You'll have to help me in this regard.
Actually, that's a good point, because this section only applies to the remunerative part of salvage.
all remunerative, isn't it?
So the rewarding, the reward for salving, in other words, independently of contract.
Yes.
So I think I may have to go back slightly on an earlier debate here. Salvage charges here are just the truly reward part of a salvage, and this section says nothing about a contract.
Well, at common law, with no contract at all, a salvor would be entitled to reasonable remuneration.
Yes.
And the reason why you have an open form instead of an agreed salvage cost in the great majority of cases is that an agreed salvage cost may turn out to be more than you would get at common law.
Yes.
With the result that you could only recover part of it from the insurer. So you have a salvage award using hindsight to assess the value of the services. But the amounts that would be recoverable independently of contract at common law would be confined, would it not, to the value of meritorious services expended on saving the ship rather than protecting the environment.
Under Section 65, yes.
Yeah.
But that doesn't answer the question, what are costs of recovery and repair under Section 60?
Well, it does go some way, doesn't it, to answering my Lord Hodges' question. Does that mean that you have a different answer in the case of how to calculate a partial loss recoverable from underwriters from the answer that you would have to the CTL question?
It does, and the answer to my Lord's question, I'm sorry, I'm a bit slow, is yes. Can I just indicate...
That raises another question of principle which Mr. Ashcroft raised, which doubtless you're coming to.
You really
which is the angel principle. the Angel question, yes.
We're going to have to let you complete your submissions because you've only got a short time left.
I do. But can I just say on that front, of course, the actual charges in the Scopic agreement do not depend on there being any threat to the environment or any saving the environment at all. And if one has that in the contract at page 371, as I've just shown, paragraph 2, the salvor can invoke the Scopic clause, second line, regardless of whether there is a threat of damage to the environment. So the nature of this contract, which is reasonably signed and then creates a necessary payment, is that the owner must pay the Scopic rates, environment charge or no environment charge. And so in those circumstances, whilst there is an obligation I would submit something less than the basic obligation to prevent or minimize damage to the environment, the owner has to pay even though there are no such services and no booms. And that is a fact in favour. And just on my Lord Hodges point, can I go to Lord Donaldson at volume 2, tab 65, page 1426 on this.
Page, sorry.
Yeah, Authorities Bundle 2, tab 65, page 1426.
1426, thank you.
1426, under the heading Contribution to the Cost of Repairs, where he adverted to this point, although not providing the question that I was asked. At the top of this, under the heading Contribution, he says, in the majority of cases, salvage will be undertaken in terms of the Lloyd's open form. Where this is the case, or if salvage is undertaken under maritime law independently of contract, the problem will not arise. The cost of salving will be whatever is awarded against the ship owner, and so on. But this was not always the case for salvage operations. Unlike salvage charges, see section 65, are not defined in the Act, and the meaning of the words covers salvage operations under contract. If ship owners can only salve his ship by undertaking to pay the whole of the cost of the operation, benefit both ship and cargo, any deductions or contributions would be inconsistent with the terms of the section itself if the cost of repairs includes the cost of salvage operation. In my view, it clearly does. All that section 62.2 is concerned with is whether the cost would exceed a certain figure, and we are bidden to include future salvage operations there. And so that is, if I may say so, a recognition of the possible difference in common law salvage in the two situations, and doesn't contradict the position that the primary purpose of the owner is to do the reasonably necessary thing to salve his ship. As a side wind, that's an overstatement of the position, but as an additional benefit, the salvor is to save the environment, and the Scopic charges are paid whether he does or doesn't do that. It is simply a necessary element of the reasonably entered into salvage agreement. And finally, so far as the Matthew case is concerned, and I really must wind up quickly, so far as the Matthew case, the Angel, is concerned, that was a case at its tab 37, I think, of number 1. I won't go to it. I'll just invite you to read it. That was a case where following the casualty, and as a consequence of the casualty, there was additional voyage insurance taken on for the continuation of the voyage at a premium of £150, and one of the insured risks eventuated under that additional policy, and it was held that the actual cost caused by the insured peril under the additional insurance could not be added in under the CTL. Instead, what was added in was the premium, the £150 premium, taken out at the port of refuge for the remainder of the voyage. And that the case was about something else, which is the cost of the wreck, and is not authority for the proposition that if you are insured by a pre-existing insurance policy against a repair cost, it doesn't count as a repair cost. And indeed, that couldn't be right. It's still a repair cost to you, though you may have indemnity against it. So the Matthew case is not to the point, and that's my submission on that. My Lords, that's essentially the submission on point 1 under Scopic. On point 2, in respect of Scopic, Article 15 has got nothing to do with this, save to the extent that it does, if it does, indicate the nature of the various charges, because what's being done here is a claim for a total loss and not a claim relating directly, indirectly, in any way relating to the Scopic charge itself, which, as I've indicated, is evidence of the damage to the ship. So that there's nothing in that point. And my Lord, in the time available to me, may I just indicate the position on what I might call the large margin point. Time being what it is, my submissions are brief, but we would invite your Lordships to deal with it, applying for special leave to the extent necessary, for this reason, these reasons. Firstly, the judge didn't have to decide the large margin point because on his inclusions of pre-NOA costs, the vessel was clearly a CTL without any large margin issue. So he didn't decide it in our favour, he didn't decide it against us. If my friend is completely right, then the one possible result is that the cost of repairs as such would be 11.2 million, and we would wish to persuade the judge that the large margin is capable of bridging that gap on the basis of Mr. Justice Flo's
By a large margin, you mean more than 10%?
The 10% is already added into the cost of repair, yes. But then there's a further margin for the risks of the...
Which the judge said was inappropriate in this case. He's decided that point, hasn't he, against you?
Well, we would submit not. He would say it's not necessary to decide any more than 10%.
Well, either he's decided it against you, in which case one might need to remit it to work out the financial consequences of that, or he hasn't decided it at all, in which case it might have to go back to him for him to decide it. But in either case, it's hardly something that we should be deciding here, is it? Quite apart from the fact that it's not within the terms of the leave.
But that is hard to contend with, subject to this, that it would be unfortunate, and I would invite your Lordships not to say anything, that if there is a remission, would preclude whether we could argue on a remission the large margin point. And also, for that purpose, to remit, even if my learned friend succeeds in total, and leaving the large margin point for the judge to determine on a remission. So that would be my alternative. Well, it's not really an alternative application. It is, insofar as my application and proposal to deal with the point is not accepted, please leave it open to the judge, is what I'm submitting.
But we'll leave it as open as the judge has left.
As it is, yes. In other words, don't add to the openness or the closeness of it. Those are my submissions. I'm sorry.
Yes, thank you very much, Mr. Berry.
Yes, my Lord. Can we go back to the wording of the statute, please, in tab 70, and start with section 61, page 1463. Where there is a constructive total loss, the assured may treat the loss as partial, total or partial, or abandon. In other words, we say that the question whether a ship is a CTL is a question of present fact about the vessel. Similarly, when you look at section 62.2, top of the page, in the case of damage to a ship where she is so damaged by a peril insured against. Again, a question of present fact about the condition of the vessel. The language is not has been so damaged or was so damaged. A ship which has actually been repaired is not a constructive loss applying this test any more than a ship that was captured and has been recaptured. It may be in both cases that it was a CTL, but it is no longer a CTL applying the test focusing on present fact. My learned friend started his submissions yesterday by saying, look at the words, where the ship is so damaged in section 62.2. But you have to ask the CTL question at the date of the NOA. My learned friend accepted this morning, in estimating the cost of repairs, you do that at the date of the NOA. You apply the CTL test at that date. And the focus must be on the condition of the ship at that moment in time. Previous damage that has been repaired prior to the moment in time is irrelevant. And the flaw in my learned friend's whole approach to this was, please will you look at the transcript from yesterday again, page 118, when he'd made his point about where she is so damaged, said this is the short answer to the case. When he was asked, well, what about when you asked the question? He said, whenever you ask the question, which is at the NOA and at the date of the writ, depending on the circumstances, the question you always ask is, was the ship damaged so that such that it would exceed the value of the ship when repaired? It was. That's not what the statutory test requires. It requires a focus on the present factual situation. And the statutory test does not involve an exercise of, in Lord Sumption's words, asking what losses have flowed from the casualty. That was page 13 of the transcript yesterday. Or what has happened since and as a result of the casualty. That's page 92. The test requires a focus on the present state of the ship at the time you are asking the question. And that is why past events that have impacted on the present state of the ship are irrelevant. You don't take them into account. If the repairs have been done, if the salvage has been incurred, they are not relevant because they are not costs that you have to incur taking into account the present state of the vessel. My Lord, while we're here on... My Lord, while we're here on section 62.2 and the words future salvage operations, I think a new point has come out, that the suggestion that is to do with liability to cargo for salvage. My lords, that is not a suggestion that has ever been made previously. All of the texts, Lord Donaldson's speech, Lord Justice Donaldson's speech, everybody who's considered this previously has taken the view that this is about a liability of the ship owners for future salvage operations, and it's a liability to which the ship would be liable if repaired. It's a liability of the ship to the salvors.
That can't be true of the first half of the proviso, because it refers to general average contributions to those repairs payable by other interests. So if one's looking at a claim on the hull policy, the other interests mean the general average contributions of cargo.
Correct.
Simply freight.
Correct.
But that provides the context for the proviso that begins but.
Yes, my lord. And the other point on this is the cost of repairs. Now, we would submit in the liability for ship's liability for salvage is not within cost of repairs, liability to the salvors, and we would rely upon on the difference between section 69 of the Act, where you have obviously dealing with a partial loss situation, but in a partial loss situation, the Act provides for coverage in respect of the reasonable cost of repairs. One sees that in 69, but it deals separately with liability for salvage charges. That's 65. 69 reasonable cost of repairs in a partial loss situation, and you have a separate claim for salvage charges under 65. So the other point on 62.2, my lords, is that all the textbooks, including Chalmers' Digest and Hart and Simey, regard that provision, they footnote Kemp and Halliday, as though it's enacting Kemp and Halliday. And Kemp and Halliday is all about a ship owner's liability to salvors for salvage, and whether a cargo's liability to contribute in general average is to be taken into account as reducing that liability to the salvors. So we submit this is about liability for the future, for future cost of future salvage operations, the owner's liability to the salvors if the ship is repaired. My lords, we say there is no answer to our point about future. It cannot mean future from the date of the casualty. And with respect, Lord Justice Donaldson's ingenious attempt to come up with a possible situation where it could possibly apply, the word cannot have sensibly been included to cover that situation. And the word future is not, my learned friend said, well, it's superfluous on your case, but this is an act to codify the law. Our point, if necessary, is this is reflecting the law, that there is only a liability for future expenses if they're future from the NOA, the date that you're making the inquiry.
Well, if that is right, why has the legislature gone to the bother in 62 subsection 3 of requiring notice of abandonment to be given with reasonable diligence after the receipt of reliable information of the loss? I mean, a natural reading of that subsection would be that one is looking to the loss that occurs at the time of the casualty. I mean, if your position is right, then you can take your time, and once you investigate fully, you discover that there are these future losses to be incurred, and that's all we look to.
My answer to that would be you go back to section 61 and that the vessel, the question is whether there is a constructive total loss at the time of abandonment, and you give the abandonment by the notice of abandonment. And there must be a total loss at that time. My lords, Robertson and Nomikos, I'll just be very brief on this. It's a case under a freight policy. Clause 5 provided that there could be a claim where there was a CTL of the vessel while chartered, and in those circumstances the policy would pay in full. On the facts of the case, there was a casualty. The owners didn't tender NOA. And the question was whether that precluded the claim on the policy. And the answer was no, because the question whether there was a CTL was independent of the question of whether an NOA had been served. We accept all of that, but it is of no relevance in this case, and it doesn't answer this case. The reason why pre-NOA costs do not count here is simply that the CTL test and the common law is by nature forward-looking, and you focus on the present condition of the vessel at the time that you're asking the question. And the question in this case, but crucially not in Nomicus, is to be asked at the date of the NOA, and you apply the CTL test. And Rura and Forgas, my lords, it said that Mr. Justice Roche held that the vessel was which was once a CTL as a result of the capture, remained a CTL after the restoration. Again, this is a claim on a freight policy, and therefore no NOA was necessary. The question being simply whether the vessel became a CTL at any time during the charter. Was it at some time a CTL during the charter? It was held that the vessel had become a CTL within the relevant period, such that there was a claim, and that claim was not defeated by the fact that the vessel was subsequently restored to the owners. And we've looked several times at page 630 in the files, which is the relevant part of the judgment of Mr. Justice Roche. And can I ask you to just read that again carefully? He's not saying that the vessel remained a CTL after restoration. On the contrary, he says two things. First, that there was once a CTL, rejecting the argument that was being made that there was never a CTL because of the restoration. Secondly, he says that restoration precludes a claim for a CTL because the loss has been made good to the assured, i.e. that there is no longer a loss at all after the restoration. And the real points of the case are that in the context of a freight policy, first, it was sufficient that the vessel had at one point in time become a CTL, and secondly, that it was immaterial for the purposes of the claim on the freight policy that she had subsequently been restored to the owner. And so in our submission, the case doesn't provide any guidance to the very different circumstances of this case, where you have to apply the CTL question as per the Act at the time of the NOA. My lords, there were other points that I wanted to reply on, but I see that my time is up, and I think I've covered the main points that I feel that I needed to.
Yes, thank you very much indeed, Mr. Ashcroft. Well, we're most grateful to all of those involved on each side who've presented us with very careful and full submissions and written arguments. We're very grateful for that. We'll now take time to consider all the material that we've been provided with.